After appreciating the evidence and hearing the parties, the trial court dismissed the suit. Issue number 3 framed by the learned trial court was regarding the jurisdiction to try and entertain the suit. However, as recorded by the learned trial court, the onus to prove this issue was on the defendants. But during the course of arguments, learned counsel for the defendants had not pressed issues number 2 to 5, which included issue number 3 regarding jurisdiction. Learned trial court also held that simply because the plaintiff had been acquitted by the criminal court, that does not bind the civil court against recording a finding against the plaintiff regarding theft of electricity in exercise of its civil jurisdiction. Aggrieved by the judgment and decree passed by the learned trial court, the plaintiff filed an appeal before the additional district judge, Hisar. The additional district judge, Hisar, allowed the appeal filed by the plaintiff and ordered the suit of the plaintiff be decreed. The defendant Nigam was restrained from disconnecting the electricity supply to the plaintiff on the basis of impugned report, and also restrained from effecting any recovery on the basis of impugned memo of penalty. Besides appreciating the evidence, the learned appellate court also recorded that when the meter of the plaintiff was not removed on 19th January 2006 because his premises was found locked, and prior to joint checking report dated 24th January 2006, the plaintiff had made a report to the defendants Nigam that his meter has been burnt, then on what basis the defendants were alleging that they had detected theft of electric energy at the premises of the plaintiff. It was further recorded by the learned appellate court that it appears that the officials of the defendants Nigam were acting hand in glove with each other just to protect the illegal actions of their officials and to harass the plaintiff for the purpose of framing him in the so-called case of theft of electricity energy. The person on whom an order has been served under subsection within bracket 2 shall be entitled to file objections, if any, against the provisional assessment before the assessing officer, who shall, after affording a reasonable opportunity of hearing to such person, pass a final order of assessment within 30 days from the date of service of such order of provisional assessment of the electricity charges payable by such person. If the assessing officer reaches to the conclusion that unauthorized use of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place, and if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection. Any person aggrieved by a final order made under Section 126 may, within 30 days of the said order, prefer an appeal in such form, verified in such manner, and be accompanied by such fee as may be specified by the State Commission, to an appellate authority as may be prescribed. Don't forget to like, share and subscribe to Lakshya Steno. Stay connected with us on social media. For any query, WhatsApp on 9991560799, link in description.